Hello, this is Dane Cialino, and we're going to talk about constitutional criminal procedure, more particularly Class 10 on consent. Now, we're having this class by video because it's the carnival season, and the argument was that traffic was going to be bad, but I think people wanted to go to the parade. And tonight looks like it's going to be the only good parade day of the whole carnival season, so I hope people enjoy it. In any event, we're going to talk about Class 10. I will tell you that this is my second run through. I already did this once and the recording did not take. So I'm going to do this a little bit more quickly than I did it for the last 45 minutes or an hour because I've already been through this once. Okay, we're talking about arrest, search, and of course, when you talk about arrest, search, and seizure, you are talking about the Fourth Amendment. And more particularly, we're talking largely about the reasonableness clause of the Fourth Amendment. All searches must be reasonable. Well, generally, to be reasonable, searches must be conducted with a warrant. But as we know, that the reasonableness clause does allow warrantless searches. According to the Katz court, these instances are specifically established, and they're very well delineated exceptions to the warrant requirement. Although all along I've asked you to ask yourselves whether or not these really are specifically established and whether they really are well delineated exceptions to the warrant requirement. But nevertheless, through them, searches that are conducted without a warrant. One of the themes throughout the course, even though the term probable cause is not in the reasonableness clause to the Fourth Amendment, probable cause plays a role in so many Fourth Amendment issues, not just warrant issues. And we know our working definition of probable cause is that it exists when all reasonably reliable facts and circumstances would suggest to an officer of reasonable caution that a particular thing or person was involved or with a crime. And there are lots of considerations that go into this, as we know: firsthand information, hearsay, and again, the purpose of this video is not to rehash issues past, but for you to understand that cause issues come up again and again. And more particularly, they come up for our discussion now because probable cause is a prerequisite to performing certain warrantless searches. And as you know, I've been keeping a chart that I like with my little green arrow and red arrow that is essentially cataloging those searches that are premised on probable cause and those. Okay, so warrantless searches and probable cause. So far, we've talked about automobiles, we've talked about search incident to lawful arrest and inventories. And we know that probable cause is required for automobile searches. We know that probable cause is required for arrest, but once a person is arrested, then you can conduct a search incident to a lawful arrest without probable cause for the search. Inventory searches, which we also discussed last time, of course, can be done without probable cause. They are done for non-investigative purposes and are done really the individual. So what are some of the warrantless searches and seizures we've considered so far? Well, plain view, and of course, in a nutshell, plain view allows an officer who is in a place where he has a right to be to reach over and seize items of obvious evidentiary value. Can't manipulate them, can't move the stereo, but if it has obvious evidentiary value, the officer can essentially reach over and seize it. We talked about search incident to lawful arrest, and of course we talked about that at length. That's about seizing and searching an arrestee, an actual arrestee, not someone who could have been arrested, for weapons of assault to protect the officer, searching for evidence so it doesn't get destroyed, within the immediate control, the chimmel grabbing area, as some have called it. And we talked historically about rules pertaining to searches incident to lawful arrest of car occupants. But the automobile exception, which we took up our last class, is a very broad-ranging exception, probably one of the more commonly used ones, that deals with an officer searching a car. And when can an officer search a car pursuant to the automobile exception? Well, whenever the officer has probable cause to believe that a crime has been committed and that evidence of that crime will be found in the car. And as we talked about, when the officer has probable cause to believe he's going to find evidence in that car, he can search the entire passenger compartment. He can search the trunk. He can search all containers in the car. We, again, talked about some historical development in that area, but now that is the simple rule. The rationales for this, of course, exigency and governmental need. Cars roll. The government needs to search that car before it rolls off. Also, diminished expectation of privacy in the sense that cars are traversing across public thoroughfares. Cars or people in cars can be seen if you're wearing a towel in your car. The truck driver next to you can see it. And there are these pervasive registration, inspection, licensing laws and regulations at the federal level, state level, and local level, such that we can't even get in a car without the government's permission in the first place. And if we don't comply with those sorts of standards, the government can impound our automobiles. Well, given that, and given some of the other case law, the rationale of exigency really has fallen to the background. It's not so much about whether the car is going to roll away, because even in cases where the car doesn't roll away, the case law has allowed the state to search those cars. It's really mostly expectation of privacy. Our last class, we also talked about inventory searches, and of course, an inventory search is one that is conducted not for investigatory purposes, but to protect the owner's property and to prevent claims against the government. So if you're arrested and you're arrested with a backpack, the government can take your backpack and can take a look at what's inside and make a list of what's in there in order to protect that property. Also to protect the police, to make sure there are no bombs or weapons in the property that they are seizing. And with regard to inventory searches of automobiles, you have a diminished expectation of privacy as to that already. What considerations bear on the reasonableness of an inventory search? Well, things like whether there's an institutionalized routine inventory procedure that is sufficient to cabin the officer's discretion. The more they have to follow written rules and procedures, the more reasonable or the more likely an inventory search will be reasonable. Sometimes courts look to see whether there's a bad faith pretext for investigative, for it to be an investigative rather than an inventory. All right, now we turn to the consent exception. This is, of all the exceptions that we'll talk about this semester, all the exceptions to the warrant requirement of the Fourth Amendment, this is the most commonly used by the police in the field. Most of the searches that police conduct that turn up evidence are the result of consent. And it always surprises me. Why is it someone who knows he's got a trunk full of marijuana is going to say, sure, officer, go ahead and search it? But it happens routinely. So what are the constitutional standards for this? And what are the rationales for a search conducted with consent? And that's our topic. For this is a hypothetical, and it's a hypothetical ripped from the headlines, to use the law and order terminology. Some of you may recall, I do because I'm older than most of you, that back in the pre-Katrina, 2003, 2004, there was a serial killer loose in Louisiana. Bodies were turning up in Whiskey Bay, and 10 or 12 women were found murdered. So there was a serial killer, and he was known or believed to be somewhere in the Baton Rouge Lafayette corridor. And there were a number of people of interest, but the police had no probable cause to arrest anybody in particular. So what they wanted to do is they wanted to go to the people of interest with swabs and try to get consent to get DNA samples. Well, and that's precisely what they did. They went from house to house with their Q-tips, asking for consent? Well, that's our hypothetical, that's our real life scenario. Is the evidence that the police obtained through those consent searches, is it admissible, or is it subject to being suppressed under the exclusionary rule? Well, it all turns on this: consent. Was the consent given by those persons of interest voluntary? And the factors that bear on voluntariness are these: was there coercion involved? Duress? Did the police lie, deceive the person from whom they were seeking consent? And what about the personal characteristics? Was this person someone who was mentally feeble or old, vulnerable? And also no duty to advise a suspect of their right to refuse consent is an important thing to consider. Take this hypothetical. Suppose the police came into a house with their ARs drawn and approached the people in the house and asked them for DNA samples. And the people say, yeah, I'll give you a DNA sample. Well, in that hypothetical, we have coercion. They're asking for consent at the muzzle of a semi-automatic rifle. They are asking for consent now. They're not telling the people that they have a right to refuse to give consent. Under those circumstances, the consent, although given, although mouthed, would not be adjudged to be voluntary. Thus, the taking of the evidence pursuant to that involuntary consent would not be admissible. The search would be considered to be unreasonable. Well, reasonableness of what the officers are doing, of course, bears on search, violates the Fourth Amendment. So under this totality of circumstances test for whether consent is voluntary, here are some of the factors that courts consider. Was there a show of force? Was there other coercion? Did they claim authority or deceive the person from whom they sought the consent? And a classic example of this that you see in some of the cases is the officers tell the person, hey, we've got a warrant. Can we search? Well, that was a lie. They didn't have a warrant. The person at that point would feel kind of helpless and hopeless. Yeah, if you got a warrant, come on in. What else can I do about it? So that deception, the false claim of authority, would all undermine the voluntariness of the consent. Personal characteristics: age, is it a young person? Education, race, mental state. All of those factors might somehow bear in. Now, race might be irrelevant in many situations, but you can envision cases where maybe racial issues did play into it and would bear on voluntariness. And there are some cases in that regard. Also a factor, not a prerequisite, but a factor. Did the person who gave the consent know that they had a right to refuse the consent? Now, again, there's no requirement that you do the equivalent of a Mirandization of a person from whom you seek consent as a prerequisite. You don't have to tell them that they have a right to refuse. And there are cases on that, of course, but their knowledge of the right to refuse is something that is thrown into the mix. All of those factors, of course, are tossed into our constitutional cauldron of factors, and then the file evaluates them. Another issue with regard to consent is what's the permissible scope of consent? And did the officers stick within the areas that they were given consent to search? So the point of this, or the starting point for this, is the person who gives consent. What did they actually say? Where did they give authority to search? Well, and that's on the kind of the speaking end of consent. What about on the listening end of consent? Did the officers, would an objectively reasonable officer believe that he had consent under the circumstances? So those are the issues under scope. Take this hypothetical. Suppose police officers have come to your apartment that you share with a roommate, And suppose that this is your bedroom and this is your roommate's bedroom. And the police officers show up and you are not home, and they ask him, can we search your apartment? And they come in and they search the living room and the dining room, and they find some marijuana. Is that going to be admissible? Well, the short answer is it's certainly going to be admissible against him. Whether it's going to be admissible against you is another issue we'll take up in just a second. But suppose he tells them, you can search my living room, but don't go in my bedroom. And they go in the bedroom. Well, that would exceed the scope of authority given to them, and that would be unreasonable for them to search in those areas. So the scope of the search is defined first and foremost by the express words of the person giving consent. And it's secondarily defined by what a reasonable officer would understand to be the scope of consent. So if a person says, oh yeah, you can search the inside of my house, and the cops go then search the outside curtilage, a reasonable officer would understand inside to exclude outside, even if it wasn't expressly excluded. So again, the reasonable scope of the search is just going to depend on what the words were that were used by the person giving consent and by what a reasonable officer would understand those to mean. All right, last issue on consent, at least principal issues. Third-party consent. Back to my hypothetical. The police come to your apartment. You're not home. Your roommate's home. And your roommate says, sure, officers, come on in and search the whole apartment. Well, as to the kitchen and the living room and the dining room, those police officers have actual authority to search those areas. Why? Oh, excuse me. Your roommate has actual authority to consent to the search of those areas. Why? Because your roommate has mutual access to those areas and common control over them. Now, what your roommate does not have mutual access to and common control over is your bedroom. And let's just assume that in your house, you keep your bedroom door closed and he doesn't go in there. You might lock it, you might not. He keeps his door closed and you don't go in there. Well, that's the way most roommate situations work, as I recall. And the officers a reasonable officer would not believe that it's apparent that your roommate has authority to consent to the search of your bedroom. It all depends on what the officers see. If it appears that this is a separate bedroom, that it's closed, the door's closed, a reasonable officer would say, hey, you have apparent authority, roommate, to allow us to search these common areas, and maybe your own, and certainly your own bedroom, but you don't seem to me, a reasonable police officer, to have apparent authority over your roommate's bedroom. And that's the way the case law interprets it. And the last issue on third-party consent is, what happens if the police show up and you're home and your roommate's home and your roommate says, yeah, sure, officers, come on in and search the kitchen and the bedroom, my bedroom. Well, if you weren't home, he could certainly do that, as we've already discussed. But you are home, and suppose you are objecting. You're saying, no, police, don't come in here at all. Well, the rule there is if you are present and you are objecting, then the police don't have consent to search that because of your presence and your vocalized objections. Even though your roommate offers to let them in, your objections mean that there's no consent for them to search at you. Well, again, it's all about reasonableness, and to bring in our reasonable man here, as Justice Scalia's opinion in Rodriguez says, to satisfy the reasonableness requirement of the Fourth Amendment, what is generally demanded of the many factual determinations that must regularly be made by agents of the government is not that they be correct, but that they always be reasonable. So the query is, would the facts available to the officer at the moment of asking consent warrant a man of reasonable caution belief that the consenting party had authority over the premises? That's what apparent authority So again, this requirement of reasonableness requires essentially that officers not be negligent, that they take in all of the facts and circumstances and process them the way a reasonable person would, and then make a decision based on all those facts and circumstances, whether there is there's authority, the person has a reasonably apparent authority to the search. Well, what's the rationale for these consent searches? Well, one rationale could be that this amounts to a waiver of Fourth Amendment rights. And we all have constitutional rights that we can waive. If you, for example, plead guilty, you're waiving your right to a trial by jury. If you give a confession to the police, you're waiving your Fifth Amendment right to remain silent. So we can waive rights, but is a consent search a waiver of your Fourth Amendment rights to a reasonable expectation of privacy in your home? Well, if it was true, then it would require that waiver be a knowing relinquishment of a constitutional right, as in Boykin. Boykin versus Alabama says that you can't plead guilty unless you are told of all of the rights that you're waiving by not going to trial and pleading guilty. Miranda, we all know you must be Mirandized. You must be told of your right to remain silent before you can waive your Fifth Amendment right to remain silent. Ferretta, before you can waive your Sixth Amendment right to counsel, you have to be told about that Sixth Amendment right. But we know that you don't have to be told that you have a right not to consent. So this waiver rationale doesn't seem to work. And also it wouldn't work because apparent authority wouldn't work. You can't be found to waive your right to a jury trial because it appears that someone else is there and waiving it for you. You have to do it yourself. So if your roommate can waive your Fourth Amendment rights, that would be odd. So that's not the rationale. The rationale is not that you are waiving your Fourth Amendment rights. What about this rationale? Is it perhaps that you have a reduced expectation of privacy after you give consent? After all, once you tell the police, come on in, search my house, you certainly don't think that you're private in there anymore. There's a police officer right next to you. No, it's still a search, and that's not the rationale. So what's the rationale? This is the rationale. Once you give the police officer consent to search, it's reasonable for him to do it. Why is it reasonable? Because you voluntarily told him that he could do it. And you know what he did? He did it. That's reasonable. And that's why this rationale is nice and elegantly simple. Police can search your house because it's reasonable for them to do so after you give them voluntary consent. All right, and that's where I want to leave it, except I, of course, want to finish up by looking at our slide with our up arrow and down arrow. Where does consent fit on this slide? Is a consent search one that requires probable cause, like automobile searches? Or is a consent search one that does not require probable cause? So this is a big question mark. Where does consent go? And let's see. There it goes. Oh, of course it doesn't require probable cause. All that's required is voluntary consent, and then the exception applies. No probable cause required. Finish up with our serial killer hypothetical. The police had no probable cause to go ask those hundreds of men to open up their mouths, but they got consent, and that was enough. All right, well, that's all I'd like to say about warrantless searches and probable cause and also consent searches. I hope that this video is as useful as a live class, and I hope you enjoy or enjoyed the parades on Thursday night before the coming rains on Mardi Gras Carnival weekend.